Hello, good morning, and good afternoon, everybody. Thank you so much for joining us here today for My HR Council's third Tuesday webinar. This month, we are talking about all things marijuana laws and how an employer can handle the complex web of all of the various state marijuana laws that are out there. So thank you so much again for joining us. We really do appreciate all of your support of our third Tuesday webinars. My name is Janelle Stanton. I am the Vice President of Communications here. And, one of my main job duties, as many of you have been with us before in previous months, is to do the third Tuesday webinars and coordinate our other educational initiatives. So I've been out on maternity leave. I had my first child, a daughter, back in January. So we've had some other attorneys filling in for February and March. I hope you guys really enjoyed those presentations, and I'm very, very glad to be back. Might be a little rusty, so give me please a little grace as I work my way through my first presentation being back after leave. A couple of housekeeping items, as always, that I go over every single month. This presentation is being recorded, so anybody in attendance will be able to get a copy of the recording. So should you want to go back and re-listen to part of it, or if you want to pass it on to anybody else within your organization or even outside of it, please feel free to do that. So just note that that is will be made available to you. We will be emailing that out in the next couple of days. You also will be able to get a copy of the slide deck. So we will be sending out a copy of the deck to, again, everybody in attendance so that you have a copy of that. So look for that in your email. And then also, everybody in attendance that stays on for the full presentation is going to be able to get HRCI credit. So if you are an HRCI accredited HR professional, you will be able to get one recertification credit for attending the presentation today. The other thing to note is because of the way we've got the webinar set up, you can't ask questions. I would absolutely love to have a conversation with you all back and forth about this topic, because I do think it is an interesting topic and something that is very fluid, is changing all the time, and I think a conversation amongst us would be really fun. Unfortunately, there's too many of us, so our conversation will have to take place through the question and answer widget on the GoToWebinar panel. So if you have a question, please type it out. I will make sure to try to get all of the questions addressed. I do know that this topic can garner a lot of questions because it is complicated. Just note, I cannot give any legal advice for this. Unfortunately, I wish I could, but I cannot. So the information I can give will just be for informational purposes only, but note that I am happy to answer all the questions that I am able to answer. So I think I've got all the housekeeping items. Now on to our agenda. So what I will be talking about today, we'll be covering state and federal marijuana law overview. I don't go through every single state and the intricacies of all of the different states' laws, but I will touch on some of them and note, since I made this deck, Virginia has gotten into the mix and passed a recreational marijuana law as well. So very fast changing topic to be paying a lot of attention to. Much easier on the federal level. We'll touch on, the difference there. We'll talk about medical versus recreational marijuana. We're going to talk about some case studies so that, we can kind of discuss what different cases have held and what they've found. And then we'll talk a little bit about OSHA and some safety issues, and then obviously follow it up with some Q&A. So jumping right into the content here, some of the overarching issues to think about regarding marijuana laws are the moral, ethical, and political implications. Everybody has an opinion about marijuana, whether it's pro, whether it's con, whether it's very, very con, whether it's tepid and unsure. Everybody pretty much has some type of opinion about marijuana, and whether it's right, whether it's wrong, and then, what the government should or should not do in stepping in to say, yes, marijuana is okay, or no, marijuana is not okay. And so because of that's why we have this big patchwork of laws. There's no one good consensus on marijuana like there is on, other things. For example, alcohol being a much more widely accepted, though not 100% accepted practice. That's just it's a different substance, and there's just a different level of tolerance and acceptance of it than there is with marijuana. I do suspect as time goes on that will change, but one thing that really holds us back from that change to sort of treating marijuana like alcohol is the lack of a scientific impairment test. I'm going to get a little scientific on you, not very. I am a lawyer, so I don't know all of the science behind it, but alcohol is metabolized through the bloodstream. And what that means is you can very easily do a blood draw, do a breath test, do a urine test to analyze how intoxicated you are when you consume alcohol. And that doesn't exist for marijuana because marijuana is metabolized through the fat. And so it stays in your system for much longer than alcohol does. And that makes the testing for current impairment of marijuana very difficult. And so I think that if science can get caught up here and can get us a nice test to determine whether somebody is currently physically impaired by marijuana or whether it's in their system but they're not impaired, once that test is a reality, if it becomes a reality, then I think things will change. And one of the things I'm going to talk about a lot today is exactly that somebody could use marijuana 2 weeks ago, your company runs a drug test, that drug test shows a presence of marijuana, and maybe you terminate based on that, but there was no intoxication. They maybe used it on a Saturday 2 weeks ago, and it just happens to still be stored in their fat because of how it's, metabolized by the body. So once we can kind of get past that hurdle, then I do think the laws and the acceptance of, or even further than, non-acceptance of marijuana, I think will progress. There's also just such a difference in all of the regulation rules and laws about marijuana. And that's why we have the presentation today. I've presented on this topic once or twice a year, every year for the last 3 or 4 years. And every year I keep adding things, I keep changing things, I keep having to take things out because it does change really quickly. And from an employer standpoint, especially if you're in multiple states, that becomes very complicated to keep track of. If we could just get one federal law in the books about this, we would be in a much simpler, it'd be a much simpler analysis for companies. We'll talk more about that. But, of course, there's community concerns about crime, tax revenue. There's a lot of, again, I would kind of put this in that moral or ethical concern area, that kind of hinder wider acceptance of marijuana. But then, like I said, the biggest concern really being impairment. And is your employee impaired? Are they impaired by their use of marijuana to the extent that them performing their job is going to cause safety issues, is going to cause performance issues, etc.? So impairment being the really big consideration here with employment law. I think I didn't update my number on this. It should be 36 states and the District of Columbia, and it's maybe even more now, have legalized medical marijuana. Almost every single state has recognized a legitimate medical use for marijuana. But these laws are so different as to how much can be possessed at a time, how it can be consumed, and then how qualified patients are able to obtain it. So, for example, some states allow qualified medical marijuana patients to smoke herb, flower, whatever you want to call it, like actually smoke the plant. Others only allow it in pill or oil format. And then some states say that patients can grow up to 5 of their own plants. Some don't allow any growing on their own and require that all marijuana be purchased at an authorized medical marijuana storefront or distribution place. So the laws about that are really different, and that again creates a lot of complexity, and it's knowing what your particular state's law says about how things can be consumed, how much can be possessed, how the patient gets it. Not necessarily something employers need to know, because what you need to know is what you need to know from the employer standpoint, and that is whether you need to allow an employee to be able to use marijuana and potentially test positive. But we'll get to that more. I just want to point out how different these laws are. The laws also differ on the conditions that qualify a patient for medical marijuana. Most states recommend recommend marijuana use for things like cancer or glaucoma. Some states will allow medical marijuana for things like Crohn's disease, for PTSD. The medical cases, use cases for when medical marijuana is beneficial to a patient is growing, and more conditions keep getting added to different states' laws for when a patient is actually going to be able to get authorization to use that medical marijuana. Now, here's where things do become an issue for an employer, is states with reciprocity. So some states will recognize medical marijuana card holders from other states, meaning if I'm in Kansas and I have an employee that is coming to me from across the way in Missouri, and I'm making this up. Don't write this down because I'm just throwing 2 states out there. But if I've got a Missouri medical marijuana card holder, and they get a job for me, my company in Kansas, and Kansas recognizes Missouri's medical marijuana card, then if that employee does test positive, I have to, as the employer, recognize the legitimacy of that marijuana card from Missouri. However, not all cases are like that. So if it's the other way around and Kansas doesn't recognize card holders from Missouri, and I have an employee that tests positive, well, then I can terminate that employee for testing positive. So again, there's a lot to be considered here, and that reciprocity with other states is something that employers really need to be on the lookout for. So just kind of an example of the difference of the state laws here. Arizona has a medical marijuana law that states that patients with qualifying conditions who are going to benefit from marijuana use may receive a medical marijuana registration identification card. And then in Arizona, employees cannot be punished for positive drug tests unless they were using or possessing or impaired by marijuana at the place of employment or during working hours. So if you have employees working in Arizona and you drug test and you find that an employee tests positive for marijuana, but that employee says, again, the example I gave, I used it 2 weekends ago on a Saturday at a party. I am not under any type of influence right now. Arizona's law would say that you cannot punish that employee for that positive drug test. And of course, this creates a whole host of new issues for Arizona employers and employers in other places that have similar laws. Is, do you believe your employee when they say, no, I'm not impaired now, I used it 2 weeks ago? Or is your employee, do they have bloodshot, red, watery eyes? Are they slow speaking? Do they have other indicia of intoxication that would point to current impairment by marijuana at the work site or during work hours? Now, again, whole new hornet's nest that we've kind of opened up there, and something that employers need to be thinking about. I would jump into it later, but I think now is a really good time to have this discussion. So to this point, your managers, your HR representatives, whoever is in the best seat to assess whether your employee is under the influence of marijuana should know what those indicia of intoxication are, especially for marijuana, but also for other drugs, for alcohol, for opioids, things like that. So if you have a drug testing policy, make sure that you tell your managers and your HR representatives and you train them on what those indicia of intoxication are. For marijuana, like I said, it's delayed response time, slowed speech, red, bloodshot eyes. For, of course, alcohol use, it's still different. So make sure that your managers know what those indicia are. And then if a manager does see an employee that they believe is intoxicated, whether by marijuana or a different substance, this is when HR or the controller or the president or CEO or whoever is up the kind of food chain needs to be looped in. And there needs to be a conversation between the two about whether those indicia of intoxication warrant drug testing and potentially removing that employee from the job site. So the reason I bring this up here is obviously it's just a good time to talk about it, but we get this question a lot at my HR council. We have an employee that showed up, they're acting kind of weird, they are, slurred speech, etc. I think they're under the influence. I want to get them drug tested, can I? I'm thinking out how that process will work ahead of time, so you're not in an emergency situation trying to figure out what the indicia of intoxication are, what your company is going to do, where you're going to send them, how you're going to get the employee to the testing facility. Thinking through all of that before you have an issue with one of your employees is super important. So just my plug for indicia of intoxication and thinking through that process and doing the training of your managers before any of those situations can come up. Another interesting thing about Arizona's laws, a federal court gave employees there a private cause of action for discrimination under Arizona's medical marijuana law. So if an employer discriminates against an employee because they have medical marijuana and they've terminated their employment, that employee can then sue the company for discrimination under the medical marijuana law. So there's a private cause of action that carves out the ability for an employee to directly sue an employer if they are terminated. So in Arizona, you also need to look at, does this employee have a disability that requires their use of medical marijuana. And in those situations, an employer is going to need to accommodate that use of marijuana. I know I'm going on a long tangent here about Arizona, but I'm using this slide sort of as a jumping off point for a lot of other topics. So here's a great question. I love this question because it's a really good one. My company is a staffing firm in the construction industry. Our policy has always been to rescind offers to anyone who tests positive for marijuana due to safety concerns, even if they are in a state where it is legal, recreational, or medical. Is this policy legal? So, awesome question, because so the answer is always it depends. So sorry about the it depends lawyer answer, but the things to think through are, is everybody that you're hiring in the construction industry, are they all truly in a safety sensitive role? Or are you hiring, project managers who are not in a safety sensitive role? They're in the construction industry, but they're not on the job site. Does that person need to truly be drug tested and then have their offer revoked if they test positive? Maybe not. It depends, of course, on this specific situation. But if an employee is in a truly safety sensitive role, then OSHA can step in to say that in those situations where an employee is in a safety sensitive role, that job offer can be rescinded because testing positive for marijuana can create a safety issue for other employees. That's not going to be an across-the-board exception, but in most states, that is going to be okay to rescind that offer under OSHA, especially if they're in a safety-sensitive role. The other thing to think about is if they're, like, for example, a DOT employee, so an individual that's going to be driving that has that DOT card. So maybe they are an over-the-road trucker, or even if they have like a forklift certification, they're driving a forklift, they're driving any other type of heavy machinery. In those situations, there are federal laws that can come into play to say that an employee who tests positive for marijuana under any circumstances is going to need to go through additional steps in order to keep their job. And usually under DOT, that's complying with and going through a whole treatment program. There's a lot of steps to that. I'm not going to get into that right now, but in the construction industry, in safety sensitive jobs, there are carve-outs, and employers do have the ability to legally rescind those job offers in the event somebody does test positive. So it's still going to be a fact-specific analysis, but just something to keep in mind. We are a DFWP company, a drug-free workplace company. What if we have employees in states where marijuana is and others are not? How would I'm not sure I'm trying to figure out this question here. We're a drug-free workplace company. What if we have employees in states where marijuana is and others are not? How would we do with pre-employment workers' comp? So if you're a multi-state employer, you do have to make sure that you are complying with the state where you have employees working. So how you do that with pre-employment, and I'm assuming you mean with drug testing and hiring and all of that, you do have to look at the state where you've got an employee that you're hiring. So making sure that, what is this clarification here? No. Making sure that you're complying with the state laws where you are hiring your employees on. You need to look into that and make sure that you're watching out for that. I guess I'm not quite sure what the question is. So if you want to clarify your question there, that'd be very helpful. Here's another one. We're a staffing firm in Arizona and Texas. We require a negative drug screen for hire with all of our clients for safety of all of the workplace. Now that medical marijuana is legal in Arizona and someone tests positive for marijuana on their drug screen, can we just ask for a letter from the doctor as proof that it's for medical usage? If they fail to provide that proof, can we legally not hire this person for failure of the drug test? Another very, very good question. So here's my answer to that. I'm going to talk about that in a couple of slides when I get to accommodations. So let's put a pin in this question for now. I'll make sure I get it answered for you, but I want to talk about accommodations in just a few slides here. All right, so I just covered Arizona, Colorado, which is really interesting because Colorado is actually the first state to legalize recreational marijuana. Very different laws in the state of Colorado. In Colorado, the Supreme Court there upheld the termination of an employee who tested positive for marijuana, even though they used the drug off duty to treat a legitimate debilitating medical condition. And the Colorado Supreme Court here held that employees who consume medical marijuana, because it's permitted by state law but unlawful under federal law, are not protected. So you can see why I'm telling you when you ask me questions about what do I do with these employees if they test positive, well, it depends on the state, because where in Arizona, you would have a lot more trouble terminating an employee who tests positive for using marijuana off duty, off employer premises. Colorado, it doesn't matter. If they even use it off duty, if they aren't using it on the employer's premises but they test positive, it's something that employers can terminate their employees for in the state of Colorado. There's no protections there. So this is why I keep kind of saying it depends on the state, it depends on the state. It's not because I don't want to answer your questions, it's because it depends truly on what the state law says. And, you know, we tend to think about in the employment law context kind of more liberal states as far as employment laws and more conservative states as far as employment laws. And usually you can kind of use that state as a litmus test for what their law is going to be on, you know, paid sick leave, on paid family leave, that sort of thing. That's not the case with marijuana laws. Here we have a state like Colorado and California that are typically a little bit more liberal leaning as far as passing employee-friendly laws. But both Colorado and California state that employees are not to be accommodated for even off-duty use of marijuana. So it's very interesting. You cannot really use that, well, it's New York, they probably allow it. Well, it's California, they probably allow it. You can't do that with marijuana because the laws are really, really varied here. So I just want to point that out. Just a couple of quirky differences that I think are interesting. As far Michigan spells marijuana with an H. I'm not sure why. I've tried to research that, and it seems like it's a legit way to spell it. But marijuana they refuse to call marijuana marijuana. They call it cannabis due to the feeling that marijuana is a slang name that has prejudicial racial implications. And so just a couple of like interesting differences in the state laws. Now, here is what I was kind of putting off answering before. There are 13 states that have some kind of statutory language that requires that employers not refuse employment or otherwise discriminate against a qualifying medical marijuana patient. And so in those 13 states, if an employee can prove that they have a qualifying medical marijuana license, or that they are a medical marijuana card holder, if they can prove that, then those employees would be protected in testing positive for marijuana, assuming that they were not intoxicated at work, that they didn't possess or use it at work. No state allows an employee to be under the influence of marijuana at work. That's not going to be okay anywhere. But these states do require that an employer not discriminate against those individuals. And so what you need to do if you have an employee who you're going to do drug testing for, and they come to you and they say, hey, I'm going to probably test positive here because I've got PTSD. I have a medical marijuana card that allows me to use marijuana. You're going to need to then consider whether you can accommodate that employee. Now, it's not an across the board. They say I'm a qualifying medical marijuana patient, therefore they need to be accommodated. What you have to do in those situations is you need to engage in the process under the Americans with Disabilities Act called the interactive process to determine whether that employee can do their job if they have marijuana in their system, but they didn't use it that day, for example. So thinking about that in the context of one of the questions we received here, if that employee is, you're hiring them to be a forklift operator, or they're in another safety sensitive role or something like that, you may not be able to accommodate that employee, even though there are 13 states that have some kind of language that protects those employees. In a safety sensitive role, you unfortunately are probably not going to be able to accommodate that youth. If you are hiring a receptionist or, just a banker to, handle cash for your customers, does it matter if they have marijuana in their system? Can they perform the functions of the job? Even though they may use marijuana at night after they go home, but they're not intoxicated when they go into work in the morning? Well, that's what you need to look into. And in those states, you're going to have to do a case-by-case analysis of the role and what the employee, what their use looks like before you make that determination. So just across the board saying, nope, any positive drug test, we exclude you, is going to get you in a lot of hot water in those particular states. Again, under the ADA, the Americans with Disabilities Act, there are accommodation requirements, because even though it is a current illegal drug and it's not protected, there are situations where protections under the ADA are required. So, for example, if one of your employees is a qualifying medical marijuana card holder, but also maybe they're in recovery from drug addiction. So maybe they test positive for, a different drug or something, and then you have to determine whether ADA applies. So if an employee is currently using some form of illegal drug, and that includes marijuana that's not protected, then the ADA says you do not need to accommodate that particular employee. But if that employee is recovering from drug addiction and they're not currently using, then that employee is protected under the Americans with Disabilities Act, and you as the employer would be required to consider accommodating that particular employee. And so if an employee has completed rehab, they're not currently using, if they're currently participating in rehab and not using, or if they were erroneously regarded as using but not currently using, all of those situations would carve out a time when protection under the ADA would apply to somebody who has been an illegal drug user. And that erroneously regarded as using but not using, what that means is if you happen to know that, John from in the accounting department, I heard he used to use opiates and so I'm going to fire him because I heard he was addicted to painkillers. But if he's not using it, again, he needs to be accommodated under the ADA. And this is for things like if John, the former pill addict in accounting, maybe he needs to attend AA meetings, or he needs to go to counseling appointments every couple of weeks or something like that to maintain his sobriety. In those situations, employers are required to consider whether an accommodation might exist. I'm just reading some of the questions here, so excuse me for just a second while I look at these. Oh, this is a great question. Okay, so for positions we hire for where we require drug testing due to safety concerns, if someone tests positive for marijuana and does not have a medical marijuana card, so they fail the drug test, can we allow them to reapply for the same position within, say, a month or so and test again? Yeah, absolutely. I think that you can. And if they're able to produce a valid medical marijuana card, and it's not a problem for them to have marijuana in their system with the job that they're going to be performing, then yes, I would say absolutely they could be encouraged to come back and apply again. This question is, everyone who is approved to use medical marijuana, they should carry a medical marijuana card, correct? Not every state has cards that are issued, but they all should have some form of authorization to use medical marijuana. And that could come in a doctor's note. So a doctor might write that their patient is authorized to use medical marijuana. It may not always have like an identification card that goes with it. So that's going to also depend based on the state. I'm just reading. All right, so I'm going to keep going on here. Again, reasonable accommodation. So this is a case called Barbudo versus Advantage Sales and Marketing. In this particular situation, the employee Barbudo, she had a medical condition that she was prescribed marijuana to treat, and she got the job. She was made an offer contingent on passing a drug screen. She told her supervisor that I'm going to fail the drug screen. I have a medical marijuana, condition for which medical marijuana has been prescribed. So just so you know, I'm going to fail. Well, I don't know where the communication stopped there, but ultimately they hired this woman. They allowed her to start working. Inevitably, she did fail the drug test. And so then they terminated her employment. They didn't ask her any questions. They just said, you failed the drug test. It's our policy that if you fail the drug test, you go. And so they terminated her. In this situation, then she obviously brought a lawsuit against Advantage Sales and Marketing, saying that they discriminated against her based on her underlying disability by terminating her and not making any accommodations. The court here holds that because the employee was working in a sales and marketing role, and use of medical marijuana after hours off employer premises would not unduly burden the employer, it was wrong for Advantage Sales to just terminate her without determining whether they could accommodate. So in that situation, the court found for the employee and said that she needed to be accommodated. Oh, here's a great question. So, do you get into any issues of HIPAA violations requiring employees to provide proof of medical marijuana allowance? And the answer is an emphatic no. So HIPAA is very much misunderstood, and I could launch into a whole thing on HIPAA, but I will spare you guys the pain and misery of that. HIPAA is very misunderstood. So no, employers are able to get and keep medical documentation that pertains to their employees when it involves things like the ADA and potentially accommodating an employee, when it involves the FMLA and providing various types of leave, when it involves COVID-19, diagnoses or treatment plans, things like that. So in certain situations, it is okay for employers to obtain and keep medical documentation about their employees, including medical marijuana cards or prescriptions from doctors. Just make sure that if you do get medical documentation from your employees, that you store it correctly, meaning it needs to be stored very securely. Only those who need to have access to those records should be able to get access to them. And ideally, it's a good idea to store medical records separately from the rest of the personnel file, because again, you want to just make sure you keep any medical information that you get from your employees very, very, very confidential. So another great question. You guys are really coming up with awesome questions. Oh, here we go. Another awesome question. I love this. And even if we don't get through all the slides, I really think question and answer is a great way to present this material as well. So I'll keep answering questions as long as you guys keep throwing them at me. So if the employer is in an at-will employment state, will the employer still be held liable for an illegal termination? So at-will employment is, again, very much misunderstood. At-will employment, every state is an at-will employer with the exception of Montana. Montana does things just a little bit differently. At-will employment means that the employer can end the employment relationship at any time for any reason, and the employee can likewise end their employment relationship with the employer at any time for any reason. However, there is serious limitations on the at-will employment doctrine, and those limitations are discrimination, retaliation, violations of contracts, violation of public policy, etc. So, yes, in an at-will employment state, employers can definitely still be held liable for an illegal termination because illegally terminating an employee is an exception to at-will employment. So you can terminate any employee at any time for no reason as long as the reason isn't an illegal one. As long as you're not terminating the employee because of their race, because of their gender, because of their ethnicity, because they previously filed a complaint of sexual harassment against your CEO, because you have violated their rights under the Americans with Disabilities Act. So there's a lot of exceptions to at-will employment, and absolutely an employer can still be held liable for an illegal termination in an at-will state. Great question. So like I was saying, other states have found that nothing in their medical marijuana law establishes a duty to accommodate medical marijuana users. And in this case, James versus the city of Costa Mesa being in California, the employee loses. California courts have not found to date a duty to accommodate medical marijuana users in employment. Marijuana laws make for very strange bedfellows, you guys, because California, we would assume California would say, of course you need to accommodate medical marijuana users, but that is not the case here. I kind of already covered that, I think, enough. Another couple things to kind of point out here, in some states with medical marijuana card holder protections, refusing to hire or terminating based solely on a positive test is not allowed. So if you get a positive test, you've got to dig in more. You have to look at that specific role the employee is going to hold and whether that role itself is able to be accommodated and you're able to employ somebody in that role who uses medical marijuana. And like I said, we don't ever say you've got to allow somebody to light up a doobie in the break room because they've got PTSD. That's not what we're talking about. There's no state where they can be intoxicated at work or possessed at work or used at work. So we're not talking about that. We're talking about the fact that if somebody used last night, they come into work today, they're not under the influence, but they're going to test positive because, right, marijuana is metabolized in the fat. And so it can be in an employee system for up to 30 days after use, depending on how frequent of users they are, depending on their size, etc. And so we're really talking about you failing a drug test because an employee used after hours off work premises. In some instances, I know that employers will ask employees to report any prescribed medications that might impair their ability to perform the functions of a job. And in those situations, if you do ask that, especially again, safety sensitive positions, often employers will say, are you using any medication that would impact your ability to do this job? If they then say, yes, I use medical marijuana, that should trigger that interactive process where you start talking to the employee about their medical marijuana use, what they're using it for, getting documentation from their physician or getting that medical marijuana identification card to justify the use. That's where you start going through that process. And ultimately, you may decide that given the role that the employee was hired for, given the amount of their use or the time of their use, etc., you might not be able to accommodate that employee. But you've got to go through the process first. You can't just refuse based on the fact that the employee might have a medical marijuana card. Let me check my questions here. Do these laws, guidelines apply to religious organizations? Yes, there's no religious exception from these laws. Recreational marijuana is super, super, super different. Very few state laws require that employers accommodate recreational use. So if an employee says, oh, I went to a party on Saturday and just for fun I smoked some marijuana with my friends, and then they fail a drug test when they come in on Monday, in that situation, most states are not going to require accommodation of recreational use. It's only requiring accommodation of medical use. Now, that's not all states. There are a few states that have legal off-duty conduct laws that would prohibit an employer from taking adverse action against that employee when they use recreational marijuana outside of work. Again, this is not on work premises, off work hours. Some states have legal off-duty conduct laws that would say you can't punish them even if it's recreational and not medical. And what about CBD? CBD oil, people are becoming much more familiar with CBD. Cannabidiol, and it's in everything. It's in dog treats, it's in candles, it's in pills, it's in essential oils, it's everywhere. But unfortunately, it's not well regulated. And so cannabidiol is a component of marijuana, and unlike THC, the component of marijuana that causes a high, CBD, it has other purported benefits of relaxation and helping calm nerves and things like that. You can find it in health food stores. Like I said, pet shops. My pet shop has CBD treats that you can give to anxious dogs. What will they think of next? We live in a wonderful world right now where you can give your dogs CBD and it doesn't get them high and it makes them relax, but it's not regulated. And so what happens is sometimes you might use a product that has CBD oil in it, but it actually has trace amounts of THC that can then cause an employee to fail a drug test. So in that situation, if an employee, unbeknownst to themselves, uses CBD that has THC in it, and they fail the drug test, they might say, no, I went to my health food store and I got some CBD and, I should be fine. In that situation, it's probably not fine. And a lot of employees have been terminated for failing drug tests, even though they thought they were using a lawful product. But ultimately, because of it's not well regulated, it had THC in it, they don't have a medical purpose to be using it. Therefore, they were recreationally using THC and are able to be terminated for that. So CBD is kind of a sticky one. We'll see if it gets a little bit better regulated here. Okay, so we have employees in 23 states. Are we allowed to cancel an offer of employment if someone tests positive for marijuana, regardless of state, if the role is safety sensitive? Our employees work with electricity and work on ladders. I can't give you a blanket yes on that because you're going to have to look at the states where you have employees, what that state law carves out as the reason for as what you have to do to accommodate. You're going to need to look at every state where you have employees. Having a blanket policy where you just didn't cancel an offer of employment is not recommended. And again, you have to prove safety sensitive. A lot of companies that I've counseled have kind of tossed out that safety sensitive justification for canceling offers of employment when really it probably wasn't a safety sensitive role. Now, being on ladders, working with electricity very well may be the case, but you still need to look at the states where you have employees working to make that determination. This always happens. I always run out of time before I can get through all my slides, but that's okay because I think we've had some really good Q&A here. I do want to touch on drug testing policies before I kind of wrap up and address any lingering questions. You definitely should have a written drug testing policy in place. For the person who asked about having employees in 23 states, it's incumbent on you as an employer to understand what the marijuana laws are in all 23 of those states and make sure that your drug testing policy applies and is compliant with all of those states, because the way that you then run your drug testing program, if you don't know what the laws are in those states, you're very likely to run afoul of one of those laws. And many of the state drug testing laws have statutes on the books that allow an employee to sue their employer for violating the drug testing laws of that particular state. Not all of them, but some. So make sure that you know what those state laws are. And having a compliant policy, hopefully that's drafted by an attorney, wink, wink, nudge, nudge, is going to make sure that you're staying compliant with all of those states where you have employees working. So you need to state who is going to be subject to drug testing. Is it just your employees in safety sensitive roles? Are you drug testing everybody in the workplace? You need to state when you're going to do drug testing. Is it just pre-employment? Do you do random drug testing throughout the year? Is it going to be done quarterly? So defining when drug testing is going to be completed. Where some states do allow employers to do on-premises urine tests. I don't usually recommend that, but if you have a big workforce and you do a lot of drug testing, it's obviously much cheaper if your state allows it for you to be able to do urine testing in your place of employment. But most states do require that you use an independent certified lab to do drug testing. Stating why you do drug testing: to maintain a drug-free and safe workplace. Putting that out there, why you are performing drug testing, and then again, how. Are they going to do urine testing? Will it be saliva? Will it be hair? Will it be blood? Make sure that it complies with what the state allows. Most states allow urine, hair, and blood testing. So again, just something to be thinking about, and making sure that if you have a policy, it complies in all of those particular states. One thing to think about too is considering whether drug testing is necessary or practical. I've talked to a lot of companies out there that, when we were in full employment situation before COVID, they couldn't find an employee to, save their lives that could pass a drug test. And so ultimately, there might be a lot of situations where you don't really need to drug test your employees, depending on the industry you're in, depending on the types of work that you have employees working in, considering whether drug testing is even really necessary. Highly recommended to look at. Like I said, establish that policy, make sure all of your employees get a copy of that policy and that you get their consent before you drug test. A lot of states require that you distribute a drug testing policy to interviewees. So not even people that you've made an offer to. I think it's North Carolina, but there are many states out there, North Carolina, I believe, being one, where you need to tell somebody who's interviewing that you require drug testing. And so that's before you even make an offer. And then once you make the offer and you are going to do drug testing, getting their consent to do that is very, very critical, especially for states that require it. I already talked about this, establishing clear, observable criteria for reasonable suspicion. So that's those indicia of intoxication. And so what are those criteria for when somebody is going to be considered to be potentially under the influence? And then what is that policy going to be? Who is going to take the employee, to the drug testing center, and all of those, non-fun things that employers have to worry about. And then most critically of all is applying the policy consistently to make sure you're not singling out employees on the basis of race or ethnicity or gender or any of those protected classes. Make sure that if you're going to drug test everybody in your warehouse, make sure you drug test everybody in the warehouse. Don't make exceptions for some and then apply it to others. That is a recipe for absolute disaster there. So this is a great question, can you have two policies, one for safety-sensitive employees and one for non-safety sensitive employees? Yes, you can. You can have two different policies. You can also just have one policy that says, for safety-sensitive employees, here are the drug testing rules that apply to you. For non-safety sensitive employees, here are the drug testing rules that apply to you. But again, if you're going to do that, make sure you apply that policy consistently amongst all of your employees. It's very just absolutely critical. So if you drug test your safety-sensitive employees, drug test them all. If you don't drug test your non-safety sensitive employees, don't drug test any of them unless you carve out like a reasonable suspicion purpose. Like if you have an employee, again, how about John in accounting? Sorry to John in accounting. But if you suspect, he's been using opiates, for example, his work is suffering, and he comes in one day and he appears to be under the influence. Well, in that situation, you have reasonable suspicion he may be under the influence and might be able to test. But again, it's going to go back to your drug testing policy. So making sure that you are buttoning up that policy and making it very clear as to who gets tested, why they get tested, when they get tested, all of those things. So we're right up on the hour here. Let me see if I've got any other questions here. I know I had a question, another New York specific question. Unfortunately, I don't know the New York law off the top of my head, so I'm not going to be able to answer that question. I will reach out to you directly to make sure I get that answered. But yeah, unfortunately, I just don't know the ins and outs of the law. Oh, I got a congratulations. Thank you. I appreciate that. A question. I think I got all the questions. Does anybody else have anything lingering that I can answer before I end the webinar? And like I said, everybody's going to get a copy of the presentation. You'll get a recording. You'll receive the HRCI credit code if you are an HRCI certified professional. But if there are any other questions, I'll kind of give it a second here. I'm not seeing any others come in. Well, I'm glad to be back with you all. I will be here for the next however long, and we will see you guys in May for the third Tuesday presentation. As always, if you have topics you'd like me to present on, things that are top of mind, or something that might be helpful to your organization, feel free to reach out, because we love to be responsive. We love to make sure that we're getting content out there that is applicable to your business and again, very helpful and informative. So thank you all for attending today. I still don't see any more questions, so I'm going to log off, and I hope everybody has an absolutely wonderful day. Thank you.